Right off the bat, the judge signals this isn't just a rubber stamp plea deal. She wants to dig deeper into Jacqueline's story. This is classic judicial discretion because in Texas, even if both sides agree, the judge can still reject the deal if they think justice demands more.
2022 CR 3998, State of Texas versus Jacqueline Wells. That party is announced for the record for the state.
Daniel Escobar for the State of Texas.
Defense.
Joseph Stateston for Ms. Wells.
And are you Ms. Wells? All right. And Mr. Stateston, when were you appointed to represent Ms. Wells?
I was appointed today. I explained that to my client that she had 10 days for me to prepare for any hearing. And we both agreed to waive that notice of appearance. Waive the 10 days notice.
All right. Ms. Wells, do you wish to continue? All right. And you understand that your attorney does have 10 days to prepare?
Yes, ma'am.
All right. And knowing that you wish to continue with the motion to revoke? All right. You need to speak up. All right. I'm showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it? Are you the same Jacqueline N. Wells who was placed on deferred adjudication in 2022 CR 3998 for the offense of possession of a controlled substance, penalty group 1, less than 1 gram, on July 7, 2022 for a period of 2 years? Is that you?
Yes.
All right, state.
Violated condition number 4 in Bexar County, Texas. The defendant, Jacqueline N. Wells, did then and there fail to report to the supervision officer as directed for the months of November and December 2022 in violation of condition number 4.
How do you plead to that? True or not true?
State waives all the violations.
Any objections?
None.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, do you still wish?
Notice how the judge makes Jacqueline admit true to the violation. That single word legally locks her into guilt for breaking probation. This isn't just semantics. It's a binding admission in court.
To plead true to violation of condition number 4. Court will find violation of condition number 4 true. Is there an agreement?
Yes, Your Honor. The agreement is for the motion to be granted and for revocation and for 10 months in the state jail facility.
All right, is that the agreement?
It is, Your Honor, and we would ask that all her back time credit apply. She has 139 days credit.
Okay.
And then the state's also going to take into consideration NIMAG number 713316.
All right, Ms. Wells, are you asking the court to follow this agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am. Yes, ma'am.
All right, I have a few questions for your client.
Yes.
Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. State your name for the record.
Jacqueline Wells. Yes.
All right, Ms. Wells, where have you been?
Nice.
Have I been? I've been in Bexar County.
No, I mean, you haven't been doing your probation. Why not? What's been
Okay,
going on?
I know last time that I came, I was supposed to be going to Sativ. That's what you recommended. And whenever I was waiting for my treatment bed in jail, Bexar County, I wasn't aware that, I just got released.
And here's the big moment the judge confronts her directly. Where have you been? This is where courtroom drama feels less like procedure and more like raw accountability. Watch how Jacqueline's excuse unravels.
Without any paperwork, so I don't know.
And so you got released and you're, oh, happy day, I'm released and I'm just going to live my life?
Honestly, I thought that I had just gotten time served or something. I didn't understand why I just got released, but I thought that I don't know. I just know it wasn't Sativ, so other than that, I just
Okay. So I want you to be honest with me, okay? I'm looking at following this plea bargain agreement, but I want to know some things about you. And then, depending on what you tell me, I will probably give you a choice, okay? But the 10 months will definitely be one of those choices. So do you have any children?
Yes.
And how old are they?
One is 15 and the other one's 9.
All Right, and where are they?
with the dads.
Okay. And was Child Protective Services involved? And what drugs have you been using since you were released?
Since I was released, meth,
Meth?
alcohol.
Okay, meth and alcohol. It appears to the court that you have a drug problem. And you need to have that drug problem taken care of. Otherwise, you know what's going to end up happening? The last time you use may be the last time you use, and then your children will definitely not have their mother in their life. You still have a chance, maybe, if you get yourself together, if you get clean and sober, you may still have a chance to be in their life. But you must be clean and sober. And the fact that you were released accidentally or whatever happened, and you've been using, I appreciate your honesty telling me that you've been using. That tells me that you need help. So if you would like, I can send you to the state jail facility for 10 months. What's going to end up happening is you're going to go to state jail facility for 10 months. You'll do your time. You're counted off on the calendar, and you are going to get back out and you will use again.
Boom, this is the fork in the road. 10 months in state jail versus a shot at rehab. This is where judges weigh punishment against rehabilitation. And here's the kicker. Most defendants think jail is the easier option, but the judge is warning her it's just a countdown to relapse.
Or I can continue you, and I'll continue you, and I'll have you placed in an inpatient treatment, or either see if felony drug court would accept her or wants her. Have you ever been to felony drug court?
Mm.
Those are the choices I can give you. So if you want to do your 10 months, I will follow that agreement, but you know yourself better than I do, better than your attorney does. But based upon your track record, when you get out of jail or a state jail facility after counting your 10 months off, you're going to go use. You're going to go be with whomever you were with before who's using with you. And you may end up dying from that. You understand? So if you want a chance to be clean and sober, to be the person you were meant to be, not the person who's picking up criminal cases, not the person who's using, then I will give you that chance to do that. So what would you prefer?
The chance.
Okay. All right. So what we're going to do,
Your Honor, may I?
yes.
So I just want the court to be aware that she wasn't actually let go erroneous or anything like that.
Mhm.
She was disqualified from status.
Okay.
So she had medical issues that prohibited her to actually go to status.
Yes.
So in looking at the case, the modifications were after status based on her previous NTR. This is her third NTR.
Okay.
So based on previous NTRs that we've had, the modifications the last time was to do status, and then after that, a felony drug court. So if Your Honor would like, we can just move forward with the felony drug court referral, see if we could get her the help that she needs.
All right. We're going to then, if both state and the defense are in agreement, I will deny the motion, alternate amend conditions. You'll be referred to felony drug court. You're going to remain in custody. And Mr. Stateson, if you can contact felony drug court and let them know that she really needs the help and she wants the help.
Plot twist, the judge denies the motion to revoke. Instead, she pushes Jacqueline into felony drug court. This is huge. Drug courts are designed to save lives, not just hand out prison terms. It's basically her last lifeline.
Help. But when they come and interview you, you must really let them know that you need the help, because I know they're getting close to probably reaching the number of persons they can have there. Do you understand? All right. So what I'm going to do then.
And I apologize, ma'am.
Yes. Yes.
It does state that she expires in July of 2024. So
We'll extend her. Yes. So I'm going to extend you, and I'm going to extend you for 2 years. But the nature of your case It's not a case where if you complete everything that you can't be terminated early. And normally in felony drug court, if you complete everything and you complete their program, they will allow you to be terminated early. Terminated is not a bad thing on the criminal side. It's not like the
Early discharge.
yes, it is not. What's the name of the movie with Arnold Schwarzenegger?
Terminator.
It's not the Terminator. So you will not be terminated, and that way will be a good way. So I'm finding violation of condition number 4 true. I'm going to extend her for 2 years, and we'll do a referral to felony drug court, and that's to take place while you are in custody. And if for any reason you get released, you know you're not supposed to be released. So if you are accidentally released or something is not right with the paperwork and they release you, you know what you need to do? Come straight to this court right away and say, Judge, I've been released and I know I'm not supposed to be released. You understand? All right, so this is your chance. You need to take it. All right? Is there anything else from either side?
No, Your Honor.
If she does not qualify for felony drug court, would you like compliance hearing?
Yes, if she doesn't, if she's not eligible, then bring her back here from the jail and we'll figure out what to do. And we'll keep Mr. Stetson, if you could make sure that you follow through till
Okay.
she's accepted.
Yes, Your Honor.
All right, thank you. Is there anything else?
Nothing, Your Honor.
All right, thank you.
Thank you, Judge.
You're welcome. 23 CR 1646, State of Texas versus Mark Anthony Wilson Jr. Can I have the parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
I'm here, Memorial, Your Honor.
And are you Mr. Wilson?
Yes, ma'am.
Are you the same Mark Anthony Wilson Jr. who was placed on community supervision in 2023 CR 1646 for the offense of possession of a controlled substance, penalty group 1, 1 gram to 4 grams on June 13, 2023 for a term of 4 years? Is that you?
Yes, ma'am.
State?
Yes, Your Honor. Violated condition number 41 on or about the 7th day of July 2023 in Bexar County, Texas, the defendant Mark Anthony Wilson Jr. Then and there refused to participate and comply with the rules and regulations of felony drug court in violation of condition number 41.
How do you plead to that? True or not true?
True.
Did you understand by pleading true to violation of condition number 41, court could find it true, grant the motion, and sentence you up to 4 years in prison? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 41?
Yes, ma'am.
Court will find violation of condition number 41 true. Is there an agreement?
No, there's not. Your Honor.
All right. Is there anything you wish to say on behalf of your client?
Yes, Judge. Judge, in this case, Mr. Wilson asked the court to follow the probation's recommendation, which is granting him, putting him back on regular probation rather than, I believe it was drug court. Yeah,
All right.
only drug court. So we'd ask the court to put him back on regular probation, rather.
All right. Probation. Has Mr. Wilson paid the restitution, or was there restitution order for the drug testing?
Stop it. Get some help.
He's been in custody on it this entire time.
All right. All right, Mr. Wilson, the court always gives people chances. If they want help, the court will provide help for them. If they don't want help, sometimes there's nothing I can do. Court is finding violation of condition number 41 true. Court is going to grant the motion. Court is going to revoke you, sentence you to 4 years in the prison, give you credit for any time served. Going to show you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? All right, you have a limited right to appeal that is as to the allegations in the motion, not the fact that you're on probation. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. Do you understand?
Mm-hmm.
All right, we can go off the record, Mr. Wilson. When I send people to felony drug court, it's because they have a drug problem. People are not allowed to write their own programs. If they could write their own programs, they would not be here. So you had a chance to be successful and you chose a different path.
Man, I didn't get a chance to anything but the most extreme. There's no lifetime. There's no nothing.
I'm sorry, I can't understand what you're saying. What did you say?
I never had a chance at lifetime or anything else. We jumped straight all the way to the most extreme. And I kept getting promised I would get out if I did this. I would get out if I did this stuff. I would get out if I did this
No,
stuff. And I
felony
never
drug
got
court
out.
is not extreme. Felony drug court is, if you would accept it, felony drug court, then they would have been in charge of your conditions of probation. If they felt that you should be an inpatient, you would have been an inpatient. You chose not to participate. You said you don't want to be on there. Here's the thing. You do not get to choose your own plan. I don't know why people think they get to choose what their conditions should be. I'm in charge of setting conditions. I'm in charge of your length of probation. And I sent you to felony drug court and you chose not to participate in felony drug court. Therefore, you're going to prison. If you would like, I could refer you to the therapeutic community. Whether or not they accept you in the therapeutic community is completely up to them because I have no jurisdiction over that. So if you would like that, you will still have to request it for them. Do you understand?
Yes, ma'am.
All right, good luck to you.
And just like that, two defendants. Two completely different outcomes. Jacqueline gets a chance at rehab, but Wilson? Straight to prison. This shows how courtroom justice isn't one size fits all. It depends on choices, honesty, and sometimes the judge's gut instinct.